Many of you have heard Jordan on the panels, but for those of you that haven't, he is a partner in the Conn Massfield Law Firm, which is a labor and employment law firm that represents employers, and he is offices in their Washington, D.C. office. Jordan has developed an incredible expertise when it comes to the Americans with Disabilities Act, particularly in Title III, and he'll explain that to you in just a moment. But he also has a broader-based labor and employment practice around discrimination issues and marijuana, as I mentioned earlier. So if you're looking for expertise in that area, he's the guy. Not gummies or chocolate, but the employment thing. But anyway, we're always very fortunate to have Jordan. He's going to talk to you today about the Americans with Disabilities Act and Title III. Yes, we will have time to talk about animals and emotional support pets. We'll be sure we get to that. But ladies and gentlemen, please welcome Jordan Schwartz.
Thank you very much, Stephen. Yesterday I talked a little too much. I'm going to try to go a little bit more at a brisk pace today so we can get to all your questions and we can get to the service animal issue as well, because I know you all have a lot of questions on that. So I'll go right past my intro. We don't need to hear about me. And I'll just start right in. We're going to talk a little bit about generally what Title III of the ADA means. Hopefully some of you know about it, but I want to make sure everyone does. And then we're going to get right into the actual website accessibility issues. So Title III of the ADA. Most people obviously have heard of the ADA, but you think about it a lot in the employment setting where you have an employee who needs some time off or something because of a disability. That is Title I of the ADA. This is I am talking today about Title III of the ADA, which is part of the same ADA that was written in 1990 and has been in place since 1992, which governs how you treat your guests who come into your hotel and what features you need and what you need to do to modify your practices and procedures. And I will get to all that in a minute. But two things I always want to say to start off the presentation. First, especially here in Vegas, is not complying with the ADA is really like going to the casino and gambling. You're taking a huge risk, and at the end of the day, you usually lose, both from a good corporate citizen perspective and from the perspective of financial or, more than just the monetary cost, the whole headache of dealing with a lawsuit. And, very few hotels can kind of just get away with flaunting ADA non-compliance and then not being sued. So we'll talk about what that means. And the other thing I always want to point out is as I think I mentioned, the ADA was enacted in 1992. I get calls from potential clients at least once a week saying, oh, I'm about to get sued, or I've just gotten sued for an ADA violation, but luckily my property was built in the 1970s, so I'm grandfathered in and I don't have to worry about the ADA. And I'm not sure where this rumor started, but that is just not a thing. There is no such thing as being grandfathered in, even if your property was built in 1865. You still have to comply with the ADA. There's certain portions of the ADA that you have to comply in what's called a readily achievable standard. Not everything might have to be the exact way the law is, but you still need to do your best to comply with the ADA. So, what does that mean? That means that for all places of public accommodation, and for now, since I'm talking to you, I'm just going to say hotels. When I have a bigger audience, where there's some restaurants, there's some there's some car stores, there's some retail outlets. It's more broad. Here we're just talking about hotels. And what you are prohibited from doing is denying services and accommodations to individuals with disabilities. But that does mean you just would say to someone who's disabled, sorry, we don't want you. No one really does that. What the ADA really gets into is what you have to have in place so someone with a disability can come and stay at your property. There's really 3 buckets. The first bucket is removing barriers to access. And this slide is really the only slide I'm going to talk about that, because then we're going to get to bucket 2, which is more of the websites. But in terms of removing barriers to access, if any of you have any questions about this after, you can come speak to me. That is about making sure you have a ramp to your front entrance, or it's flat and you don't have only stairs. Making sure you have an automatic door opener if that is required. Making sure you have the appropriate number of disabled guest rooms. Making sure in those guest rooms there are appropriate grab bars, there are roll-in showers where required. The features of your rooms are certain heights. That you have a lobby bathroom that is accessible, that if you have a pool, there is a pool lift, and I can speak for the entire hour about things you need. Most importantly, the things that are most visible to your most guests. So parking spots, making sure you have accessible parking spots. Again, the ramp. I had a client who called me last week after I told them they needed the ramp, and they said, look, here's a picture of a ramp. And it was a ramp, and then there was like a 6-inch lip, and then there was the ground. I said, I like that you got the ramp, but it's actually not good enough to have the ramp if someone can't fully and easily just wheel right up onto the ramp. And they said, oh, the construction company, they said it was okay. And I said, I don't care what the construction company says. People tell me all the time, oh, they signed off on it. That doesn't matter. I mean, I'm the bad guy, I'm the lawyer. But I try to protect you from the worst case scenario, and B, the worst case scenario can actually happen. We had dinner 2 nights ago with April. Some of you met her. She was just on the panel with us right before, and she's a plaintiff's lawyer, and she unfortunately had a case where there was a lip like that, and someone in a wheelchair tried to wheel on, it hit the lip, it rolled over and fell, the person hit their head, they eventually ended up dying. So she was representing their family right now. So these are things that are not only theoretically good under the ADA, they actually have a ton of importance practically speaking. So that's number 1, the physical barriers to access. Again, that's about all I'm going to talk about that for today. Number 2 under the ADA is you need to modify your policies, practices, and procedures in order to be ADA compliant, and that's where we get to the website issue. And then number 3 is if you have meeting rooms like this, I know many of your hotels are smaller than this, but if you have public meeting rooms, you need some sort of auxiliary aids and services for people who are hard of hearing or hard of seeing. If you have TTY equipment, if you have make sure your TVs have closed captioning. Potentially, if there's any menus, to have larger print menus, have Braille outside your guest rooms, things of that nature. Those are required for effective communications. But let's go right now to website accessibility. And when I talk about website accessibility, here are again 2 different buckets. If you call me and say, I was just sued because my website is not accessible, I will ask you which of the 2 buckets you are in here, because they both fall under the rubric of website accessibility, but they are very different. And we're going to take them one at a time. The first one is, does your actual website need to be accessible for users with visual, hearing, and physical impairments? So I'm going to focus the next 20 minutes or so on that, and I'll tell you why that's more complicated. And then the second question is, forgetting about whether your website is accessible for users with visual, hearing, or physical impairments, is, does your website provide enough information so that someone, most likely in a wheelchair, can look at your website and know whether or not they can go to your hotel? And that is the first bucket falls somewhat on Choice because Choice designed some of your websites, although I know many of you have vanity websites and you actually design it, and that's part of the reason I want to delve into it a little more. The second bucket, though, is fully on you, because at each of your properties, you are the only one who knows what accessible features are actually at your property, and then what needs to be listed on your website. But let's talk about part one for a few minutes here. What I'm talking about here is the actual website. What happens is someone who has difficulty seeing, they probably from their end use something called screen reader software that allows them, it's a program that they use that allows them to have the website either read to them, or the contrast gets brighter, or the font gets larger, and then they are able to utilize the website from their end. From your end, or from Choice's end, the website needs to be compatible with this screen reader software. So that is what I'm talking about right here, is the data on the website compatible with screen reader software? Now, the question is, and I hate to get all too lawyerly on you, but I have to kind of talk about the intricacies of the law. When the ADA was enacted in 1992, it again applied to places of public accommodation. A hotel is a place of public accommodation. What the ADA doesn't say is whether a hotel's website is a place of public accommodation. Websites didn't really exist in 1992. So this isn't in the statute. So we have to go by court decisions. And courts have ruled on both sides of the issue as to whether a website is a place of public accommodation, and thus whether it is required to be ADA compatible. But almost all courts are now saying it is required. I will explain to you the few courts that have now just changed course and said that it's not required. But the trend is for websites to be considered places of public accommodation, and then they need to be compatible with something called these Web Content Accessibility Guidelines. It used to be 2.0, now it's 2.1, it's about to be 3.0, and I don't need to get into the details of that. But that is what we're talking about, trying to make websites compatible with these Web Content Accessibility Guidelines. And all of this really started in 2017. When a customer wanted to go to Winn-Dixie in Florida, a grocery store. And she went onto the website, he went onto the website, I've defended a few cases against Mr. Gill, and wanted to print out coupons. The website was not compatible with screen reader software. He ended up suing. He won. And the court basically talked about how the website was part and parcel with the grocery store. There was a nexus between the two. The word was a gateway. So what the judge said, if you have a website that's a gateway to a store, the website needs to be ADA compliant. So that was in 2017. Since then, most courts have relied on this case as kind of the general background for their rulings. But this was all kind of thrown into a little bit of a disarray just last year when the 11th Circuit, so that's Florida, I believe it's Louisiana, and Alabama. I think those are the three. It's definitely Florida. So if you're in any of those states, you need to be aware, because those states, the court reversed and said, you know what, we're reading the statute, we don't really see where the court came up with this language. We are actually going to say that the website for Winn-Dixie is not considered a place of public accommodation. So 4.5 years later, we're ruling that Winn-Dixie actually won this lawsuit. This ruling, again, is only limited to those few states. Other than that, that is the law of the land is the opposite. But in Florida, which sometimes people know Florida has some different rules, the rules are a little bit different. And just as a little bit more of an example, here's a case from New York that came out after Winn-Dixie in 2017, but is still being relied on. It was relied on last week in another court case, saying that websites are places of public accommodation. And it went further here and said even a website, let's say like eBay or Amazon, even if it doesn't have, even if it's not a gateway to a hotel or a store, it still needs to be accessible. And then the one other really important case to talk to you about right now is from the Ninth Circuit, and that's out in the West. That's California, Nevada, where we are right now, Oregon, Washington State, and similarly, the Ninth Circuit has ruled that a place like Domino's, if you're trying to order online, or any hotels, do need to be the websites need to be accessible. They're considered places of public accommodation. The interesting thing in this case was the lower court actually ruled the opposite, but then the Ninth Circuit came in and ruled that they do need to be a place of public accommodation. Then the Supreme Court, it was actually petitioned to the Supreme Court, and the Supreme Court said, you know what, we're not going to get involved right now. We're happy with this Ninth Circuit ruling. So the Supreme Court, in essence, deferred to the Ninth Circuit ruling. It has not ruled on the issue. Now, with this new 11th Circuit ruling, the Supreme Court at some point needs to rule on the issue because it's called a circuit split. But you really want to pay attention to this Ninth Circuit ruling. So, okay, what are we talking about here when we're actually talking about website accessibility? What are some of the key issues? The biggest issue I'm seeing now, and it changes every few months, it changes based on what the plaintiffs and their attorneys are doing, but it's menus in PDF format. Most of you have probably been to hotel websites or restaurant websites where you say, click here to see the menu of the hotel or the restaurant in the hotel or just a regular restaurant, and then it puts the menu up on your screen in PDF format. If it does that, almost in all likelihood, that menu is not accessible, and that means the entire website is not accessible. Starting recently, some PDFs are starting to change their properties so you can make a PDF accessible, but 9 times out of 10, you see this and a plaintiff sees this, and then they're going to sue you because they see that the website is not accessible. Also, if you have pictures, symbols, maps, diagrams, without written descriptions, links to just click, and where they say click here. And the other really big thing is if your website doesn't allow you to use the keyboard for everything, and there's certain things that you need to do on the website only clicking with a mouse, that also shows that it's not accessible. Because someone who can't see, they need to be able to use the keyboard, and the keyboard can help them function without being able to see. It can help them navigate the website. But with a mouse, you need to be able to see where the light is blinking to click, where it says click here, and you click the mouse. So that shows that a website is not accessible. So if you are designing any of your vanity sites, or you're on them, or you're dealing with choice on these actual websites, you need to make sure that they do these steps 1 through 5, which is providing text alternatives for when there are pictures and maps, providing captions, text captions for audio content, making all functionality available through the keyboard as opposed to just on a mouse, and avoid using color as the only means of conveying information. Those are really kind of the key things that you want to be aware of. There are some tools you can use, and I have some listed here. Wave, the Functional Accessibility Evaluator, that can help determine if your website is accessible. Those tools only get you so far. They can tell you if you're not accessible. They can't really tell you if you are accessible. There's really no other option other than to use a human, a person as an ADA consultant, and I'll get to that in a second, who can actually do human testing and determine full-out accessibility. And if you figure out your website is not accessible, all this slide says you need to come up with a plan. You want to get buy-in from Choice or from the leaders in the organization and come up with a plan to make your website accessible so that it's accessible with the latest guidelines, which is WCAG 2.1. I mentioned you want to retain an accessibility consultant if it gets that far. They're the ones that can help you make sure your website is accessible. The one issue with that though is if you may retain an accessibility consultant and that's it, and then you get sued, the first thing a plaintiff's attorney is going to ask for is, let me see all your records of your past website. Let me see what the accessibility consultant told you. Let me see how you weren't accessible. I'm suing you because I don't think your website's accessible. You're saying it is. I'm going to find all the records that show that it wasn't accessible, which is why you had to hire an accessibility consultant. So the way to get around that is you also need to hire someone like me. It doesn't have to be me, but it needs to be an attorney. The attorney shouldn't cost very much. They shouldn't be fully involved in the entire process. They need to be tangentially involved. They need to work with the accessibility consultant, so when you hire the consultant, there can be a document that says the accessibility consultant was hired on the direction and advice of legal counsel. If you do that, then every single thing associated with the accessibility consultant, including the hiring of that person, is privileged. And then you don't have to turn it over when a plaintiff asks for any documents. And you can say that is privileged, you do not have the right to know that. And that can really help if there is a lawsuit. That's really all the technical things I want to talk to you about in terms of how to make your website accessible. In general, under the ADA, I get asked this question a lot, so I wanted to make this slide here. People say, can I be sued twice by different plaintiffs for ADA website violations or just ADA violations in general? And unfortunately, I have defended some hotels who have been sued 3 or 4 times. And in this one case, it was actually Guy Haynes who sued Hooters a few years ago. And Hooters defended the case saying, we're not liable, we already settled with someone else last year. And we're in the process of making our website accessible. Why should we be liable again? And the 11th Circuit said, we don't care that he settled with someone else. Right now, when this plaintiff sued, your website wasn't accessible, and you have an obligation to make it accessible. This individual is just trying to enforce his rights. He's not bound by the settlement agreement. So when I represent a client, and often we end up settling cases because defending these cases are really expensive, they're really time consuming, and a lot of times it's just easier to settle. So when I enter into a settlement agreement with the plaintiff, I get as much time as I can for you to make fixes to your property or make fixes to the website. Sometimes I'll even get you 2 years, because sometimes you have to make substantial fixes to your parking area or to guest rooms. So I want as much time as possible so that you are not contractually obligated to this plaintiff to have to fix everything in a few months. Let's say when COVID happened, if I didn't have all that extra time, some of my clients would have been able to make all the fixes. That being said, let's say I get you 2 years, or get the client 2 years. That only protects them against this individual. This individual cannot sue or cannot do anything, cannot even go to the property for those 2 years to check out if you made the fixes. But other people can still go to your property. They can still find non-compliance. They can still sue you. So I tell them you have 2 years, but you should make your fixes as soon as possible to alleviate any potential lawsuits by anyone else. So that kind of protects you both ways. That's really the only defense to these lawsuits, is making your changes that you might need to make as soon as you can and being more compliant. I have, what did I have written down right here? Sorry, the words I used were, yeah, it is critical to take action as soon as possible to ensure both your hotel and your website is in compliance with the ADA. So I'd like you just to remember that phrase. I don't need to talk to you specifically about the facts of that case, and there's a few other cases here. I don't want to bore you with case law, so I'm just going to move past those cases. The next thing I want to talk to you about on your website is something called an accessibility statement. I'm not sure if you all have this on your websites. I'm not sure if you know if you have this on your website, but it's something to check out. It is a fairly basic statement. I wrote one for a client yesterday morning right before I did this presentation. It's 2 or 3 paragraphs. And what essentially it boils down to is we are ADA compliant on our website. We do our best to maintain ADA compliance. We've even hired someone to evaluate our ADA compliance. If you have any questions, if you have any concerns, if you've had difficulty navigating our website, please email me or call me, and we will do our best to address your issue. And it sounds simple, but a lot of websites do not have this. And I'm not going to get into the details of this next case. You can see some of the bullet points listed above. But in this case, a plaintiff sued, and the Playhouse, or the place of public accommodation was a Playhouse, actually did have an accessibility statement. Usually I tell you about cases where the defendant did not. The defendant did have an accessibility statement, and the court ruled on behalf of the defendant. He told the plaintiff, you don't have a case. You thought there was a policy that made your life more difficult. The website said to call. You did not call. You have no basis to allege that they violated the law. So having an accessibility statement on your website has been proven. I can't tell you it'll always avoid lawsuits, but in some cases, it has caused a court to rule on behalf of the defendant. So keep that in mind. It's an easy thing. It takes an hour to come up with good language to put on your website, and then you're protected at least in that way. Let us know. I know I'm going quickly, but I really we ran out of time the other day, so I really want to get to the second part and then the service animals. The second part is kind of a little bit more practical, so this should be a little less theoretical here. We are talking more now about how you run your hotel combined with what you need to list on your website. And this is not based on case law. It is based on the actual regulations promulgated by the Department of Justice for the Americans with Disabilities Act. And what part 1 of these regulations say, and there's 5 parts. Part 1 says you need to make sure that individuals with disabilities, and I have it highlighted here, can make reservations for accessible guest rooms during the same hours and in the same manner as individuals who do not need accessible rooms. You all by now should be doing that. As of a few years ago, there were plenty of hotels who said, anyone who needs a non-accessible room can make a reservation on the website. We do have accessible rooms. However, if you need those, call us and we'll help you out. In that case, calling doesn't work. It's not like the accessibility statement where you're providing a number. Here, you're making someone with a disability do something in a different way that you're making everyone else, and that was not sufficient. So here on your website, I'm pretty sure you have it so you can book an accessible room or a non-accessible room. So you should be good there. Part 2, though, is where the issues start to arise. Ensure that accessible guest rooms are held for use by individuals with disabilities until all other guest rooms of that type have been rented. So if I come to your property and all of the rooms are open, and I say, I just want a king room, and you say, oh great, I have a king room, you know what, I'm going to give you the first room, it's an accessible room, go enjoy. That is not valid under the ADA. You want to rent your other rooms first, So someone with a disability comes in later and needs an accessible room, you aren't in the position to say, sorry, we don't have any accessible rooms for you because we've given all of them away. So that is something you definitely need to keep in mind.
What happens when that happens?
If someone comes in and you don't have accessible rooms,
Yeah, because 6 other accessible guests are in there, and here's the 7th guest that did reserve it, but they somebody else stayed over in that room.
well, we talked about, well, if they reserved it, you should do what you can to honor their reservation. Let me change the hypothetical a little. There are times where someone who is not disabled is in an accessible room. Of course, that happens a lot. Someone who with a disability makes a reservation. They come in, and then the person who is already in the room has extended their stay. In that case, you should try to see if the person who extended their stay can move rooms, because there's already a reservation for that room and the individual with a disability needs it. If an individual with a disability comes in and there's no rooms available and they didn't make a reservation, you can say, I'm sorry, we don't have a room to meet your needs. We'd be happy to make a call to a different hotel down the block, but there's nothing we can do. Someone in this presentation yesterday told a story that they said we only have regular rooms available and and the individual said, oh, that's fine, I'll take the regular room. And then he ended up complaining that it didn't meet his needs and suing. But that's a one-off. You have to take people at their word. If they say they need an accessible room, you try to find it. If they say they need a non-accessible room, you can give them a non-accessible room. So that's kind of how we address that. Yes?
If somebody shows up and we need a room that book our room is not available, we offer an alternative option, send it to another hotel that have it and cover the charges with that.
Yes, let me read these 2 points first, and then I'll get right back to you. Because once someone reserves a room under the ADA, you are required to block that room from your reservation system and have that room being honored. And even if someone, let's say you have accessible room 312, and someone stayed in it last year and they really like that room, if they request 312 and it's reserved, when they come, they should be getting 312. It's not good enough to say, oh, sorry, we know you reserved it, but we'll put you in 322. Granted, you can tell, if that happens, you can tell the person, I'm sorry, I know you reserved 312. Right now, someone's overstayed, but we have 322. It's got the exact same features. Is that okay for you? And if they say yes, you're okay. But what happens often, and you can follow up the question if you want, but what I'm trying to avoid, what gets people into a lot of trouble is, sometimes front desk agents or people who aren't in a wheelchair don't know all the in and outs, don't realize some of the differences. So someone in a wheelchair specifically reserves a room with a roll-in shower. And your hotel probably has, let's say, 4 to 6 ADA rooms in your hotel. A couple of them have roll-in showers and a couple of them don't. And that's fine, because some people want roll-in showers, some people need them, some people don't. So what happens is someone in a wheelchair reserves a room with a roll-in shower. They get to your property, you say, the front desk agent says, sorry, we don't have that room available, but I have another ADA room, that'll meet your needs. And it turns out that ADA room doesn't have a roll-in shower. This person's, ends up falling, they tried to use the tub, it didn't work, or they're just generally not happy because it wasn't what they were requested. And that is really, it puts a lot of pressure on your front desk person. And it's against what the actual regulations say. So if someone reserves a room and it's reserved, you should do everything you can to have that reservation be adhered to. Does that answer your question? Okay. Yes?
So you can have a room with a tub and still be considered ADA compliant?
Yes. A lot of people don't realize that, but there's 3 types of ADA accessible rooms. There's mobility accessible with a roll-in shower. There's also mobility accessible with a tub. And then there's hearing and visual accessible. And depending on the size of your property, there are a certain amount of each that you need. And what people don't realize is the visual rooms only 10% should be the same as the mobility rooms, because someone who's visually impaired might not want all the grab bars and everything there, and vice versa. But yes, people sometimes say, oh, I only have 2 mobility accessible rooms. When I say, oh, that's surprising, you have 100 rooms in your property, you should have 4. They're, no, I'm pretty sure I only have 2. Turns out they have 4, they just had 2 roll-in showers and 2 with tubs. But mobility accessible rooms doesn't necessarily mean a roll-in shower. But there are specific threshold requirements for how many of each you need to have. Same thing with how many parking spaces you need to have. And I'll get to a little bit more about room types in a few minutes. But this next slide, this is the big slide where we're talking about website accessibility lawsuits. And it's, you are required to identify and describe the accessible features in your hotel, both public features and in your guest rooms, in enough detail to reasonably permit individuals with disabilities to determine whether or not they can go visit your property. This one little sentence that I just read is the subject of so many lawsuits. And it's really easy for someone sitting at home to look at your website, instead of going to your property and saying, oh, you didn't have a grab bar, they can look at your website and say, you didn't list enough information, I'm gonna sue you. And they're allowed to do that. I've defended a lot of these cases. So the question is, well, I think I said you need to provide enough information. What is enough information? It's really a little bit of a common sense analysis of what you're going to list on your website. What should happen is there should be some sort of tab, maybe where you have your accessibility statement. It doesn't have to be there, but it probably should be. So some sort of tab for accessibility. A user clicks on accessibility, and then you have the accessibility statement that says we do our best to comply, here's our number if we don't, and then you say, here are the accessible features at our property. And then you start with the public features. And you know, me or someone like me can help you do this if somehow you don't do it. And again, this is your responsibility. It's not Choice corporate responsibility. They're not at your property. So you have to talk about, we have accessible parking. We have an accessible front entrance. We have a restroom on the first floor that's accessible. We have a restaurant that's accessible. There's an accessible route from the parking to the front entrance. If there's not an accessible route, that's a problem, because then you're putting someone in harm's way where people are driving and people are wheeling at the same place. You talk about if there's an accessible route from the front desk to the accessible guest rooms. So there's all these things you need to provide about the public areas of the, probably, I don't know, between 10 and 20 bullet points you can list about the public areas of the property. You have to be a little bit careful. You want to list as much as you can, but you don't want to provide wrong information. You know, if you say you have an accessible ramp, let's just use that example, then someone gets the property, they try to use it, and it's not accessible. Even if they don't slip and fall, it's still an issue. So you don't want to entice someone to come to your property and list the wrong information. The ADA actually says you should list what you do have that's accessible and what you have that's not accessible. I don't quite go that far. I don't really like advertising on your website something you have that's not accessible. I just think that's too easy for a plaintiff to grab onto. So I only like listing what accessible things you have about your public areas. Yes?
Like a fitness center, and you've got a small area, like somebody who's handicapped, not going to be able to get onto a treadmill, is that, do you need to have?
Jordan, can you repeat the question, please? Yeah.
Yeah, it's a really good question about fitness areas and what to do about accessibility in fitness areas. And it's really challenging when you have a small hotel. Bigger hotels, it's easier. But a fitness area is a public place of accommodation, or it's a public area in a place of public accommodation. So it does need to be accessible, but what that means, that doesn't necessarily mean you need equipment for someone in a wheelchair, but the door can't be too heavy. Someone in a wheelchair needs to be able to enter the door. If you have towels on shelves, there needs to be some towels that are less than 48 inches high above the ground, above the floor. There needs to be enough maneuverability space so someone in a wheelchair can use it. And then if they just wheel to the place where there are free weights, and that's the only thing that's okay. I'm not saying you have to have some sort of equivalent to a treadmill, but there needs to be sufficient space to maneuver, sufficient space between each machine, and especially going in and going out. Sometimes there's a phone, the phone's gotta be lower, if there's a water and a towel. So, but that is a public room. Some of those public rooms, laundry room, a fitness center, those are the ones where it's really difficult. In some way, I would argue everything's important. I'm the lawyer, I'm defending you. But I tell my clients more often, a lot of these plaintiffs are coming in without a specific intent to stay in your property. They might not even go in. They're called drive-by plaintiffs sometimes. So the more public-facing things you can fix, the better. Make sure you have accessible parking spaces. Make sure your front entrance is good. Yes, I want your fitness center to be ADA compliant, but you're not going to get as many drive-by lawsuits looking at your fitness center. You might get some. In terms of the we talked a minute ago about the information you want to put about public spaces. Also the information about the guest rooms. You want to put the bed type, the number of beds, and the type of bathroom. As I said, it can be a roll-in shower, it can be a tub with accessible seats. That you want to list that. You want to say, accessible king bed, accessible queen, and I'll get to that in a minute, more about the dispersion of your rooms, so that someone knows that you have these accessible rooms, and that someone can reserve online an accessible room that has these specific features. And that'll come right into this dispersion issue. So what the regs say is your accessible rooms must be dispersed among the various classes of guest rooms. Okay? Remember, we said at the beginning, the ADA says you can't discriminate against someone with a disability. So if you have rooms with king beds, rooms with queen beds, rooms on higher floors, rooms with suites, and you tell someone with a disability, yep, everyone else has all those options. The only option for you is a king room on the first floor. That's it. Plaintiff would argue they're being discriminated against by not having choices. You don't have to provide every single choice, and of course some rooms probably want to be on the first floor. But if you have suites, one of the suites should be accessible, especially because one of the barriers to making accessible rooms is a lack of space. A suite usually has more space, so it should be easier to make that room accessible. Also, it's tough with space, but most accessible rooms, from my experience, happen to be king rooms. They all shouldn't be king rooms. Again, one, people want choices. Two, individuals with disabilities are sometimes traveling with a companion. The companion may not be their spouse. It may be someone who's assisting them. They may not want to sleep in the same bed as their companion. You really should have at least some, technically it should be about half. It should be commensurate to the same number, the same percentage of king and queen, or king and double queen rooms you have for non-accessible rooms, you should have for accessible rooms. No one's gonna, hold your feet to the fire if it's not the exact same percentage, but what I'm telling you is you want at least one room with 2 queen beds that's accessible.
If we don't have the space to create a 2 queen bed accessible room, accessible to be able to give them a room next door, like one's accessible.
Can we give them an adjoining room if they have a companion that doesn't need the disability? My thought would be probably not, but let's see what Jordan said.
I'm gonna disagree with you on that.
There you go.
One, if you don't have room for 2 queens, see if you can get a room for 2 fulls. It's not exact, some plaintiff could potentially argue that's not the same, at least it's still 2 beds. If you don't have room for that, if you can get it, if you give them an adjoining room, so there's 2 beds, I'm okay with that. It's not absolutely perfect, I'm okay with it. Do not charge them for the adjoining room though, it's just 1 room. Similarly, if the only thing that's available is the suite, and the suite has 2 beds, you say, you only asked for the regular room, we have a suite, and trust me, hotels mess this up sometimes, do not charge them for the suite rate, you charge them for the regular rate. If they ask for a suite, of course you charge a suite rate, but anything you're doing to kind of cover up the fact that you don't have something, even though if they're getting more than they otherwise would have, do not charge them for something that they're otherwise entitled to by the ADA. Are you okay with that, Stephen?
Absolutely.
So that's the dispersion issue. We actually see a lot of lawsuits just based on this dispersion issue. They're up, we looked at your available rooms and you only have rooms of this type, you're not adequately dispersed. We also see a lot of, I don't have this in my presentation, but I do want to mention it. We see a lot of properties that get sued for not having a proper loading zone and what's called an access aisle right at the front entrance of your property. If you don't have a marked access aisle in yellow or blue or white, it doesn't matter what color, right at the front entrance to your property, you're playing with fire. That's a lot of, talk about the drive-by lawsuits. They are looking to see if you have a loading zone. And there's technical requirements for how long it needs to be and how wide it needs to be. And it's called an access aisle along with the loading zone. People hear that and they think the plaintiffs are talking about the access aisle next to a handicap parking space, but it's not. They're talking about access aisle next to a passenger loading zone. Few more quick things and then we'll get to the service animals. Third-party online travel agencies, Expedia, Orbitz, plaintiffs are not sometimes, a lot, plaintiffs have been suing you guys for their failure to include accessibility-related information at your property. And I get calls all the time, this is so unfair, how am I being held responsible? They're the people who messed up. It doesn't matter. The law applies to places of public accommodation, to hotels. Expedia is not a place of public accommodation. So it is your responsibility to have this bullet point list that we've talked about with your accessible features and provide it to them so they can list the accessible features at your property. If their representatives deposed, they might say, well, we never got the list. At least if we have to defend this case, the best thing we can do is say we provided them with a list, now it's not our fault. The plaintiff's going to say, I don't care, I need someone to address the wrongs that were committed against me, and I can't sue them, but you need to at least make sure you review their websites, and if they don't have your hotel's features, if they don't say provide accessible guest rooms to be booked, you need to contact your contact there and discuss that with them. I have a few more slides about that, but I'm not going to talk about the specific court cases that have happened with OTAs. Jessica, that's all I'm going to talk about right now because I do want to get to the service animal issue. I don't know what time it is, but I know we don't have a ton more time.
Yeah, let's get to that. That's great. So ladies and gentlemen, I know that the difference between a pet and a service animal is important. Just to preface, his remarks around this topic as we pull these slides up. All of you, more than likely, have a pet policy. You either do not allow pets, or you charge a pet deposit, or you charge for a pet to stay there, right? What you have to keep in mind is that there are pets and there are qualified service animals, all right? And we're going to walk you through how to make that determination. Your pet policies do not apply to qualified service animals. If they're a qualified service animal, you can't charge extra, you can't charge a deposit, you can't exclude them from the property. Think of them as Jordan will tell you, as part of the owner. Jordan, take it away.
Yeah, so the definition of a service animal is a dog or a miniature horse. And that is it. There's no other service animals. We're different than airlines. Airlines might have different requirements, but under the ADA, it is only a dog or a miniature horse. And you cannot impose a surcharge or some other type of cleaning fee for a service animal. Again, a service animal is not a pet. It is an extension of the person who's using the service animal. And when someone comes in and says they have a service animal, there are only two questions you can ask them. Your hands are kind of tied. It's, is this animal needed because of a disability, and what work or tasks has this animal been trained to perform? That is it. The difficulty is there's not really any follow-up questions you can ask. But if the answers to those questions are no, you can deny them. If they're yes, you are required to accept them. And what you are not required, you are not allowed to do, and I don't think it really exists. Some people seem to say it exists. One second. But you can't ask for any sort of proof or certification of either the individual's disability. You don't hear that too much. But you can't require proof or certification that the animal is a service dog, or what the training is, or anything in that nature. And I'll ask you a question. You can require the dog to be harnessed or leashed or tethered. And we were talking to someone yesterday, and they were saying how the dog was so out of control and peeing everywhere. And if the dog is not housebroken, if the dog is a threat to others, if there's anything out of control, then you can disallow the service dog. But otherwise, you need to allow them basically everywhere the individual goes with the individual. You don't allow them in the pool. You don't allow them on the tables in the food area. But other than that, you allow them. And then, the rubber meets the road, so to speak, when the question everyone has is, what about comfort animals, emotional support animals, those animals? The law says they are not service animals. You are not required to accept them. What Stephen and I kind of believe in is, yep, that's the law, and you can do as you see fit. You can deny them, but people are often pretty attached to their emotional support animals, and if you don't let them in, they could cause a whole sort of ruckus and end up suing you, and you'll end up, I would think, winning. And at the end of the day, you pay me a lot of money, and we decide, it wasn't a service animal. You get a pat on the back for winning that. Whereas if you let the comfort or emotional support animal in, you deal with that for 2 days and then you move on. So
And you take their money.
Yes, you take their money. You can use the pet policy.
Yeah.
If they argue on the pet policy, again, that I would stand a little bit more firm on. But yeah, typically I would allow them, but you are not required. I'm a lawyer. Under the law, you are not required to.
I think our perspective is that this is really the time for you to be the gatekeeper or the sheriff of Nottingham. Use your judgment, but we know people will try to take advantage of you. We get that. But hey, look, when it's all said and done, there are really people that need this. And we don't want to preclude somebody that really needs it by being cynical, right? So try to keep our ego in check, not be cynical, but recognize that allowing somebody to do this is not the end of the world. Take their money, go on down the road. I know that can be hard for some people. No, that's not true. She said, it's not, that's just not accurate. And that's not what we're saying. So I encourage you to think a little differently about that, right? Because this is a big deal. And you can get, you can,
Is those emotional support animals, they,
well, they do, and we're not saying that, Jordan's been saying, you don't have to do it, so, but you obviously have become rather cynical about it, and I'm trying to encourage you to perhaps think a little differently to keep yourself and your hotel out of some trouble in the future.
Stephen, he's
Yeah,
had his
Yeah,
hand up for a while.
yeah, let me get over there.
Keep from damaging anything. Also gives them better traction.
That's emotional intelligence, we're gonna talk about that in the next hour, we'll
Horses
talk
can
about
sleep.
emotional intelligence, and hopefully that will help you deal with these situations a little differently. Yes, sir?
So can we ask our guests the question when it comes to service animals
Actually, like little
specifically?
tennis shoes in the bottom.
If we hear the animal barking, indicating, making noises, what is the thing we need to tell the 911 operators when we call them? Is that a question we can ask? Because a service animal barking and indicating like that would indicate that there's an emergency of some sort. Would it then be incumbent upon us to do something if we hear it?
Are they put on notice if a service animal begins to bark as though they're alerting something, I
Can we
suppose?
ask that question of the guest?
Can they ask when the guest checks in, do we have your permission? I assume you're saying, do we have your permission to contact 911 if we hear the animal barking?
Yeah, because that's how you kill the emotional support animal BS. If I hear your dog bark, I'm calling 911. What am I telling them? You have diabetes, Huntington's,
Well,
PTSD.
Don't do it.
Because if it's an emotional support animal running around the hotel barking, you call the police enough, they're gonna leave.
yeah, I like the idea of, do I have your permission to call the police, but that second part to say, what exactly am I
You
telling
have,
them?
yeah, you gotta be
That's
careful.
asking specific questions about their disability, both with guests and employees, you usually don't wanna do that. Like, I see what you're saying, but and you can say you're not required to tell me, but would you like to volunteer any information? I don't love it, but I understand if it's working for you from a practical perspective, I'm not gonna tell you not to do it, I don't love it though.
Yeah, Hope.
You made a statement earlier about the animal being required to be on a leash. Can you clarify that? Because I don't think that that's actually true from, is there a difference between having the animal under control and being?
Yeah, it's gotta be under your control.
So it doesn't have to be.
I don't believe it has to be on a leash every second.
Yeah.
You can, although I do believe you can require it. I do believe there's a chance you can require it, but I'm not sure about that, actually.
I think the way the law reads is that the animal has to be on a leash unless it impedes the function of the animal.
The dog be on a leash unless it impedes the function of the animal?
Function of the
That's
animal.
fair, yeah,
So it's kind of in between the two.
yep, here we go.
So just backing up a little, if they say it's a service animal, we put them in the room, the dog chews the carpet up, or we can go back to the pet policy on that and charge them.
Yes.
You can collect damage, you just have to charge a pre-stay.
Okay, and then how many, does the ADA limit how many service animals one person can have?
Ooh.
That's a great question, and we get that frequently.
I
Jordan?
don't think I've ever figured out, I don't know if I've ever followed
Right?
those areas.
Yeah, well, I think the way you look at it, I think you go through the analysis on each animal. Right, and so, because somebody
It's
could have
possible.
two, yes,
Someone could have two. I would
Two.
think anything more than two is a little crazy, but it's possible.
3. For the same reason? Yeah, I don't, yeah, that's one of those situations where I think you just got to go with your instinct. That's challenging though, right? Because one typical qualified service animal is almost always sufficient in my experience.
Yeah,
Jordan,
that's why I asked that question.
The guests try to clean up with their
Yeah.
limits, and
Yeah.
then wondered why they got
we
$800.
guys, we got time for like 1, maybe 2.
Are service animals in training given the same opportunities or restrictions?
I've never heard that question.
I don't know. I'm sorry, I gotta be
Yeah,
honest.
that's a tough one. Service animals in training. Yeah.
Usually when we see someone coming through our property with multiple, it is I have one service animal and one that is in training.
Well, that's an interesting situation. My perspective would be if they have a qualified service animal with them, I would probably,
Leave it alone.
Right, that's
Take them
a
in.
little
Yeah.
different, again, I don't
Yeah.
actually know, but when
We have
it only
police
has
stay
one
with
of
us,
them,
law enforcement, they bring in their
Yeah.
police
then it's
dogs.
not really a service
And
animal.
they say,
But the second one,
my
yeah.
guest service agents will be like.
Hold on one second,
Is
guys.
that a service animal? That's a, those dogs protect.
You are
officers,
able
they're service
to,
animals.
require that the service animal not be left unattended in the room, correct? Because they should be providing the service to that person.
I have to
That is
take that
correct.
out.
Yeah, I think that's a fair thing, and that's why I would suggest, we'd like to get your mobile number in case, you know, the dog creates a nuisance, we want to be able to reach it, and that lets them know you expect the dog to be with them all the time. All right, last question. Sorry guys, we're not gonna get to everybody, but I gotta get Jordan out of here.
I have a service animal for my boy, and my understanding is that they have to have the vest on all the time as they are serving. So if someone comes to the front desk without the vest on, I mean, I know you can't ask what kind of animal it is, but can you say, the dog must have a vest on, you must have a leash?
Now, just to be clear, I think you're referencing a harness as opposed to necessarily like one of the marketing vests that they download. Oh, there
Okay,
we go.
which property?
Yeah, a harness.
Correct, yes.
I think that's fair, yeah, the harness, but that's part of the control question, I think, right? I'm not sure what the real answer specifically about
You
that.
said there was a card that was
Control as
expired?
well as identification.
it doesn't have to be,
It does not have to.
nope.
That's the hard
When
part,
did
right?
it-
But we get, we have to
what
take
time
their
did
word
this come
for it,
out?
but we understand it, we understand it's frustrating. What I'm trying to suggest to you is that try not to make this your line in the sand moment.
All right.
I know it's hard, but I suggest
At
it's
2 p.m.
better to take the
Well,
money
we had
sometimes
talked to,
than to
we're
draw
at
the
the
line in
convention
the
right
sand.
now.
That's
We
what I'm
talked about,
suggesting. Let's say thank you to Jordan.
We have two accounts. And one is,
Just
one
can
account we
do
regularly
the,
bill on, the other one is,
QR code
we,
real quick in
we
case
can
anybody wants it,
continually
with our
get
relationship with
statements
Choice.
with,
At
nothing
site,
due.
you can access
And
hospitalitylawyers.com
we're
for
trying to
free.
see if we can
All
get
of our
that second
libraries,
one,
all of our form
shut down, or
checklists
what's
and
going on with
procedures.
that.
So I encourage you to do that. She'll pull it up here in just 1 second. You can do it from your seat. I'll be starting in about 15 minutes. The final talk for our team this
33253.
year on emotional intelligent leadership. And one of the things we'll talk about is how to manage these types of situations because they can be very frustrating. I know they can be. All right?
The one
We'll
that
see you soon.
isn't, I mean, it hasn't had any
Thank
activity
you.
on it. I think it's going on like 2 or 3 years now.